What damages are recoverable under the employment laws varies to some extent from employment law to employment law. Virtually all employment laws permit the recovery of lost wages and benefits. Lost wages are, as the name implies, any wages that have been lost from the date of the termination, for example, until the date of the jury's verdict. And that, more specifically, is called back pay. And so, as a remedy, you can certainly recover your back pay up until the date of the jury trial. You can also recover what's called front pay. Front pay is pay that you would have earned had you not been fired in advance or in the future of the jury's verdict. Front pay is up to the discretion of the court. It's sometimes granted, it's sometimes not. When it is granted, it's typically granted in about five-year increments. Now, it's incredibly important that a plaintiff make sure that he diligently look for a job after he's been fired or terminated, because the law imposes a duty to mitigate, which means, as the name implies, you have to mitigate or lessen your damages. We routinely advise our clients to thoroughly document their job search so that they can show that they complied with the duty to mitigate damages. It's my preference to hire a financial expert to assess and summarize the economic damages that my clients suffered. And the reason for that is that I think it's counterproductive to have the employee or the plaintiff explaining to the jury how much money he or she is asking to be awarded. Most employment laws also allow for the recovery of emotional distress damages. Emotional distress damages, as the name implies, are basically your mental injuries. How have you suffered emotionally as a result of the discriminatory act? Under federal law, there are damages caps on how much emotional distress damages can be recovered. Those caps vary depending on the size of the employer, but for most employers, the damages cap for emotional distress is $300,000. Now, we oftentimes accompany any federal claims that we bring, federal discrimination claims that we bring that are subject to the damages cap. We often accompany those claims with a state law companion cause of action. And the reason for that is there are no state law damages caps on emotional distress, and we want the jury to be able to exceed the damages cap if it so chooses. There are a small handful of employment laws that also allow for the award of liquidated damages. Liquidated damages are double damages. We talked earlier about the definition of back pay. In a statute that permits liquidated damages, you can get double whatever the back pay award was. And so for plaintiffs pursuing claims under the Age Discrimination Act or the Family Medical Leave Act, they can recover liquidated damages of their back pay. Another category of damages is punitive damages. Punitive damages, once again, as the name implies, are designed to punish an employer or defendant for its conduct. I mentioned earlier that there's a damages cap that can restrict emotional distress damages to $300,000. That same damages cap applies to punitive damages, such that the emotional distress and punitive damage awards cannot combine to exceed more than $300,000 under several of the federal employment law claims. Most employment statutes also permit the plaintiff to recover attorney's fees and costs through something called a fee shifting provision. And basically, if the employment plaintiff prevails in his or her suit, the court will order the defendant or the corporation to reimburse the plaintiff for his attorney's fees and then the costs of the litigation.